I think also now we have a good way to go from theory to practice and to hear to my colleague, Judge Raffaele Sabato. Judge Raffaele Sabato, he's graduated for the famous and renewed University of Naples. Afterwards, he got a master in University of Texas Austin in the States. He had a career in the judiciary, a very distinguished career in the judiciary, where he arrived to be judge at the Supreme Court of Italy, but also in the cooperation of the High Council of Judiciary with several organisms, including being president of the Consultative Council of the European Judges here in Strasbourg. Also, Judge Sabato has a theoretical background and also taught in several universities in Italy and abroad. And I'm looking forward to hear Judge Sabato talking about the European Court in times of emergency, how the court has been working during the pandemic, the derogation under Article 15, and the relevance of health emergency in the application of the convention. Please, you have the floor.
Thank you, Julia. I'm grateful to Professor Motok, my very close colleague here in the European Court of Human Rights, and I'm grateful to Euridice for organizing such an efficient and very, very interesting seminar. I've been happy to hear previous discussions. In the 10 or at most 15 minutes that I can take of your precious time, I will discuss two separate but in some ways connected topics. In one way, just give you in 3 minutes a sort of sample of what the pandemic has meant for the operation of the European Court of Human Rights. So I would say a few words on what has been our procedural experience. And then I would make a very short, but Professor Motok already said many interesting things on this topic in her introduction, on Article 15 of the European Convention, one article that we would wish never to be applied, but nonetheless is always relevant. And so I would connect these two topics by saying that even the court herself in sometimes has experienced and is experiencing a sort of time of emergency. So let me go back to the beginning of the pandemic and to the measures that the Strasbourg court took in order to face the incoming emergency. As it has happened in many countries, the main role has been played by press releases. And this is strange to say for lawyers, but with an immediate press release, number 94 of 2020, then there will be two important ones, 103 and 108, but let me concentrate on the first one. Deadlines, some deadlines were exceptionally suspended. And so this was one first effect. If we only think that the 6 months limit in order to apply is provided for by a rule in the convention, by way of a press release, the European Court of Human Rights decided that that deadline should be suspended. There were, of course, other suspensions that were included in that press release, but those were deadlines that the court assigns to parties in order to file documents, to submit replies, and similar measures. You can imagine that there our surprise is less important. Let me say that from that day on, our activity, as it has happened for the Luxembourg court, for other international courts and all of the domestic courts has radically changed. We have been starting, as you well know, to work on the internal level on a remote basis. There were some very scarce references in our rules of court to support that. Then adjustments have been made on the go, I would say. And on the other side, some improvements and some investments also from the financial point of view have been done by the court and by other courts for what concerns electronic communication and electronic and remote management of proceedings. Just to make a long story short, the court, as you well know, holds not so many public hearings, but it does. And those hearings at some point have been managed, has been suspended, first of all, and then later on, when the pandemic was hitting a little bit less, were managed in a remote way. Actually, they were the modalities were hybrid, because the judges were sitting in court and parties would be connected remotely. Let me mention here, as I was mentioning the suspension of the 6 months time limit, one exceptional measure that was taken and which in some ways distinguishes our court from other courts at the domestic level. The European Court of Human Rights, you know, is very strict and very proud of the requirement of a public hearing under Article 6 of the European Convention of Human Rights. So we would think that being impossible to hold the public hearings, these would be substituted by some sort of direct streaming. Well, this was not the case. In some grand chambers that we had with no possibility for the public to get into the court, we kept our usual ex post streaming starting a few hours later than our hearing had taken place. So public control was sort of postponed of a few hours, and you know that this has very strong reasons, because usually very delicate issues are discussed in court, and one thing is that everybody hears the names and details of possible vulnerable parties and other things in presence, and another things that on a streaming, direct streaming, you can learn about people that can suffer serious violations, and they could even be persecuted afterwards. So it was necessary indeed. And one more time, we think of what Julia has said concerning emergency. It was necessary to keep the possibility of editing and having beeps on names and possibly on images of people in hearings held remotely in our court. So these two examples give you the frame of topics that I would have liked to address. Let me finish this first part by mentioning that after that initial part, the court has invested a lot on electronic communications, and now a new e-com investment is underway, and those of you who serve as lawyers or have a chance to have an interplay with the court have noticed that new instructions are being issued, and new possibilities will add to that in the near future. Second part, Article 15. I would just say very quickly that rules concerning emergency are not necessarily in all of the domestic constitutions. For example, my own country's constitution, the Italian constitution, has no rule on state of emergency. The Weimar Republic constitution, the French constitution, the Spanish constitutions, for those that I know, on the contrary, have such rules. What the history behind Article 15 teaches us is, in my opinion, very interesting. So I would dwell a few seconds on some historical background. So basically, at the end of the 40s, at the United Nations level, work started on the International Covenant on Civil and Political Rights, which would end in the mid-60s, of course. But then the discussion of the state of emergency, which Professor Motok mentioned, started there. And on this other side of the Atlantic, we were sort of discussing the same issue here in the environment, which would then become the Council of Europe. There was a draft of the European movement, and there was a draft Universal Declaration of Human Rights, which did not provide any exceptions in times of emergency. There was an article in the draft of European movement which contained a clause according to which rights were subject only to limitations provided for by the general principles of law recognized by civil nations. You know that this formula will be very fortunate, so to say. So basically, we came to a point in which in 1949, a very famous French intervener in the preparatory works of the convention put forward a proposal that introduced the concept of public order, security, and the concept of necessary in a democratic society, which will then sort of expand, as you well know, to a number of rules in our convention. At this point, the clause which will become Article 15 was drafted, and so you see it's closely linked to other possible limitations on rights and freedoms of other articles of the convention. There was an opposition, I know because I am from Italy, and our delegate, coming from an experience of a country who had, of course, had fascism, said if we introduce such an exception, those forces that violated existing human and fundamental rights in the past might use it, might invoke, I'm reading it, this clause, and we have been used to this over the last 20 years. So I wanted to recall this sort of historical background to see how dangerous and important at the same time Article 15 is. A parallel to Article 15, then we find in the Paris minimum standards of human rights in a state of emergency, but these Paris standards, and this is also very interesting to reflect upon, are very long, and the International Law Commission introduced a number of interesting limitations. For example, a state of emergency under those principles is relevant only if it concerns an entire territory or at least an entire region. And the European Court of Human Rights has taken another way on this concept. I think that Professor Motok already mentioned that. The role of parliaments. State of emergency under those principles should be declared domestically by a parliament and for a pre-established period of time. Of course, you can renew it. But so they are very, very restrictive, which is not the constitutional experience that we have had during COVID, which has been so the experience of our generation, I would say, and we will have to reflect on that over the next few years. So I cannot go longer. I have to conclude. Let me say a few things on how Article 15 is sort of managed by our court, by the Strasbourg court. So basically, it is placed as the first rule after the great list of Declaration of Rights. So before it, we have Article 14 on prohibition on discrimination. So this is the first article after the list, which introduces a sort of bridge between the list and some other procedural and sort of institutional rules. Let me say that the rule in time of war or other public emergency threatening the life of the nation. Which nation? This is a European convention. There are many nations, but you can hear the rhetoric and the history which is behind this rule. Any high contracting party may take measures derogating from its obligations. So there are obligations under this convention to the extent strictly required by the exigencies of the situation. And this is very wide, provided that such measures and so on and so forth are compliant with other obligations of international law. Let me say that this is a rule that we have to frame together with what I said before, the internal limitations that we have in the so-called second and third paragraphs in the other rules, the ones that set standards for rights and freedoms. So basically, the idea is that the fact that in our convention, what does not occur in many constitutions, we have at the same time internal limitation and this sort of generalized possibility of a state of emergency makes a choice necessary. And the court made its choice with this formula. When we have a case, we first examine the internal limitations that we have in each article. So if we take, for example, Article 8, famous respect for private and family life, we go to the second paragraph and we read interferences that might be justified, etc., democratic society, national security, public safety, and the economic well-being of the country, similar to the nation, disorder of crime, protection of health, there we come there. Basically, the court does the following reasoning. Is there a violation if we only apply this limitation or not? If there is a violation, then I will go to the derogation under Article 15, and not vice versa, because otherwise we would not get into connection with society and societal facts, and possibly facts could escape our assessment. So we go first there, and then we come to Article 15. This is very important, and this explains why decisions and judgments on Article 15 they exist, but they are not so frequent. Second and final part, of course, countries have a wide margin of appreciation in assessing whether or not there is a state of emergency, but this does not mean that in case we go to Article 15, the court has no supervision on the requirements in order to declare a derogation. Therefore, second supervision, the internal limits, the strictly necessary, the concept, our former president, Alexandre Sicilianos, although this is not in Article 15, in a conference he held in St. Petersburg over the days of the pandemic said, probably here we have to transfer the clause of necessity in a democratic society, which is not spelled out clearly in Article 15, but is inherent when we talk of the strict limits or the exigencies of the situation that we have mentioned before. Final remark, really the last one. Let me mention that the three paragraphs that we have in Article 15 are very closely interrelated one to the other. So paragraph 1, the requirements in order to have a state of emergency. Then we go to paragraph 2, which means that there is a procedure. So there is a declaration. We go to paragraph 3. Sorry for a moment. This is better. There is a procedure. So there is a declaration that has to be filed with the Secretary General of the Council of Europe. Let's go back to paragraph 2. And there in paragraph 2, we have rules that are not derogable by way of declaration of a state of exception. And you will not be surprised that we have there not only rules that are obvious, protection of life and from inhuman and degrading treatment, but also rules pertaining to criminal law that are not derogable in times of emergency. Therein included Article 4 of Protocol number 7 on ne bis in idem. This is quite important. Julia, and this is the way I wish to conclude, mentioned that a number of countries made such declaration during the pandemic. About 10, I think. I have them here. I did not count them. But what is interesting is to note that the countries that made those declarations, for example, do not include my own, which has been severely hit at the very start. They do not include France. They do not include Germany, etc. I tried to find what the reason was. And the reason is possibly the fact that there had been criticism in legal scholarship on what had happened on some very sad and very important events in European history in which state of emergencies had been declared, and then the European Court of Human Rights or legal doctrine themselves has believed that there were no requirements. I will only mention one, another very sad but so to say less important one concerning France at the time of Charlie Hebdo. You remember, France was heavily criticized. And I think that this criticism has left something behind that we should remember. So I do not mention other things, but this was an example. So we had Albania, Armenia, Estonia, Latvia, North Macedonia, Moldova, Romania, San Marino, and Serbia. Many of these countries declared around March and withdrew the declarations May, June, September 2020. Some of them, Latvia, for example, or North Macedonia, had the two-step declaration withdrawal and then a new declaration when another wave of the pandemic started with another withdrawal. This is also very interesting. Some of them included the rules that they wanted to be derogated. Some other countries, they did not make specific lists of conventional articles to be derogated, but just submitted to the Secretary General the list of laws. One of them was for sure San Marino, who at the very beginning did not really make a declaration, wrote a letter and sent their laws. Romania transmitted also military orders, which was interesting for us to read, and I did not have time to discuss with my Romanian colleague the impact, etc. I must finish, and I'm sorry that I took a little more than the time that was allowed, but you see that the topic will probably require some reflection when we will not be so still nervous, and we will be able to assess all the legal and historical framework of the state of emergency vis-a-vis the European Convention on Human Rights. Thank you.
Thank you very much, Judge Sabato, for the way that you have presented also the functioning of the court during the pandemic. I would say the good functioning of the court during the pandemic, but also for the overview of the complexity of the situation regarding the emergency in our convention, in relation with some constitutional order, in relation with some our order, and also with the covenant. And indeed, if we don't have yet case law in this regard, we have to be a little bit careful when we discuss about this, but it's sure that, especially regarding my country, we have some cases invoking Article 15, and it will be interesting to see the solution of a court. You rightly said that in the past, countries were criticized by the academia or by international courts or international body like the Human Rights Committee of the International Covenant for Civil and Political Rights, who has a provision regarding the state of emergency. And some of them more reluctant to adopt this other for historical reason, like your own one. But the other question is the following: what is better, to adopt this provision, to say what you are going to do, or to do without saying? And this is a kind of a more theoretical dilemma, but also policy practical dilemma that a lot of countries face. We are going to see what will happen. Now we are reaching the end of the first panel, and we are looking for the questions for people who are outside our panel, but also questions from the participants in our panel, because I saw that the last conference I moderate with Juridice, speakers were quite shy. They are, I think, in the real life they have more courage, but I don't know why with the webinar they're a little bit more shy. Unfortunately, Professor Churchill had to leave. He told us this at the beginning, that he had classes, so it's not possible for him to be with us anymore. So I don't see any question or comment now.
Julia.
Yeah. Yes,
Matthias. Je voulais saluer tout le monde, car moi aussi je dois partir.
Voilà.
J'ai écouté les interventions jusqu'à celle de Raffaele, et je voulais dire merci à tout le monde, et j'étais très heureux. Merci à toi aussi d'avoir organisé, de m'avoir invité à cette manifestation. C'est important qu'on puisse échanger, même comme ça, de loin, mais c'est précieux. Merci à tous les intervenants. J'ai beaucoup apprécié et c'était très riche. Merci à tous et désolé car je dois vous quitter moi aussi.
Ouais. Merci beaucoup Mathias merci pour tout, pour ton intervention et pour le fait aussi de nous avoir écoutés. Merci.
Merci, au revoir.
Au revoir.
Au revoir. So.
I would perhaps use the opportunity to ask a question regarding these differences between states in whether declaring that they're using Article 15 or not, because the measures, the underlying situation is the same. and the measures are also largely similar, so they cannot be both right. I would personally also prefer to have, let's say, restrictions assumed to be part of Article 15, because that would be an acknowledgement that is really something extraordinary, so it's meant to come back to normal, as opposed to stretching the convention otherwise and to argue that the current form of the rest of the articles actually can accommodate these massive restrictions as they are. So there are basically two aspects to the situation. One, in terms of principle, I think it's preferable to place everything under the derogatory regime because it shows it's exceptional. And secondly, is this issue that not everybody can have right at the same time. So there are some states, based on the same underlying facts, considering that they cannot place themselves under the rest of the convention, while others obviously had a different view. And I would appreciate your views on that.
Yeah, thank you very much, Mr. Bondok. I think that this was a question for Judge Sabato. Yeah, this was a comment and a question. Indeed. And afterwards, you are going to talk yourself about this theme again. Please, Raffaele.
Yes. As I was probably mentioning before, and this is probably the best way to shortly answer to Mr. Bondok, the distinction is between sort of those countries that feared that something could happen with the court because of complaints, and those other countries that sort of kept their blood cold in that respect, and those that probably decided to just do it anyway. And as I tried to show, they did it in a sort of way in saying, these are the laws. I don't even say that I want to derogate. There was one country, I will not mention it, that did not say. Some listed the derogations. Albania, Estonia. Estonia had probably the longest list, and was very interesting to read it. But I will make a joke. Just to make something that is usually heavy and as I said, makes us very nervous. And unfortunately, my country has been severely hit, and yours are as well these days. I was noticing that Article 12, right to marry, has no second paragraph. There's no possibility of an internal limitation. But in my country, at least, which was the first one, then probably the other ones had a way to arrange marriages in a remote way, or with somebody going home of the newlyweds and marrying them. For a month or so, there were no instructions on how to marry. Everybody was at home, and this was not urgent. It was, of course, urgent. Probably somebody will have married that we don't know yet, but the legal, so to say, conclusion was then it would be better to have a derogation. No country listed Article 12 nonetheless among the rules that they wanted to derogate. But the joke has some serious part, and we saw, probably in the future, as I said, we will reflect. And thank you for this question, which was very interesting.
Thank you.
Thank you very much. So I said I thank Raffaele. I just said that we are quite late because we are after 2 hours from the beginning of the conference. I will not joke that this is Romanian time of doing things. We like to discuss, and it's for me is more difficult to cut the speakers online. That is even in the face-to-face life is difficult, but online it's even more difficult.